one of the important issues that all major manufacturers, including the OEMs, have to constantly juggle and deal with is the contract labor. Yes, it sometimes is cost effective to deploy contract labor rather than the permanent work one, but it may always not be compliant with law, and hence one has to be very careful while dealing with the subject of contract labor. Hello, friends. My name is Amol Apte, and you are listening to the Lex Prudence podcast, Automotive Industry Series. As you are aware, we have been discussing legal issues around the automotive industry from OEM's point of view. If you have not had an opportunity to listen to the previous episodes, then please do listen to the same. It will give you a great perspective and continuity to what we are discussing in this episode, as well as the upcoming episodes. So, in this episode, we are discussing contract labor. All of us are aware that there are a lot of areas within a manufacturing entity where you may not always be able to deploy permanent labor. It may be on account of the fact that it's something temporary in nature, or it may be something that's taken up only as a short term project, or something that's not a perennial work, and you will end up requiring labor that's hired via a contractor just for that short term or temporary job. Now, we all know that the Contract Labor Regulation and Abolition Act 1979 is the anchor piece of legislation that deals with the issues relating to contractors, principal employer, and the contract labor. And it is very important for a legal professional working for an OEM to have full understanding of this statute and the major areas that will be affected by the uh, uh, compliances under the statute. Now, as you are aware, on Lex Prudence podcast, we keep things non-technical and try and simplify legal issues as much as possible. I will try and break down the statute also in parts so that it's easier to understand the applicability and the areas which one needs careful evaluation from an in-house legal resource point of view. I'm not going to use any technical legal jargons of the statute to keep it as simple as possible. So let's begin with understanding the intent of this act first. Mind you, we are discussing Contract Labor Regulation and Abolition Act 1979. And as is abundantly clear from the name itself, this act is a piece of legislation that intends to A, regulate, and B, abolish contract labor. So intent is very clear. They want to abolish the contract labor, and wherever there is contract labor remaining, they want to regulate it. The moment a statute intends to abolish something, it's very clear that those things, if at all, are allowed, will only be allowed in certain exceptional circumstances, and so is the case with contract labor. Uh, the Act under Section 10 allows the appropriate government, and I'm not getting into the definition of appropriate government. From industry to industry, it differs, and therefore one needs to refer to the Act to see which is the appropriate government, whether it is state government or the central government for them in that particular scenario. The Act under Section 10 allows the appropriate government to issue notifications to abolish contract labor within their purview or within their jurisdiction or within their territorial jurisdiction. Now, Section 10 is very clear. It actually allows them to issue notifications to abolish contract labor. But I have, in my experience, seen that in a few states, the notifications have been issued for allowing deployment of contract labor in certain specific jobs or certain specific nature of jobs, say, for example, housekeeping services. So one needs to keep an eye on the notifications that the government is issuing under Section 10 and appropriate government is issuing under Section 10. Be very clear that who you are as an industry, who is your appropriate government, and then only pick up a notification and see whether it applies to you or not. You can't just simply pick up the notification issued by a state and say that it applies to me. You have to make sure that it's an appropriate government for you, and therefore uh, it becomes important for you to know who is your appropriate government under the Contract Labor Regulation and Abolition Act. Now, the Act also has introduced certain concepts. A is principal employer, B is contractor. Both of these entities, that is principal employer and contractor, need registration with the appropriate authorities appointed by appropriate government before employing and deploying the contract labor. So if you are an employer or you are an OEM looking to contract with a contractor who to supply contract labor, then you'll have to make sure that you as principal employer are also registered, and the contractor who is going to supply you the contract labor is also a registered entity with the under the provisions of Contract Labor Act. The Act also provides for making principal employer liable for certain violations by the contractors, and therefore it makes it very, very critical for legal professionals who are working for OEMs or principal employers to review the contracts between principal employer and the contractor with utmost care. Because the moment there are violations, the provisions of the Act allow the appropriate government to hold principal employer liable for the violations under the Act. So you enter the shoes of your contractor and become liable. And therefore, it's very important for you to be aware of certain things under the statute so that you're able to create appropriate environment of contracts, vetting of contracts, and the processes that need to be followed once the contracts are executed and the deployment begins during the term of the contract. Now, looking at the above three things, that is concepts of principal employer and contractor, their registrations, and then principal employer being liable for the acts and omissions of the contractor, there are following three things that come to my mind. A, abolition and the notifications issued under Section 10. That's the first and the foremost thing that an in house legal resource needs to understand and take care of and keep observing and keep monitoring. B, registration requirements for principal employer and contractor. As I spoke, as I just spoke, you need to be very clear, or you need to make sure that you as principal employer are registered, as well as the contractor that you are uh, signing up with is also registered contractor under the Act. And third, obviously, are the obligations of the principal employer in case of failure by the contractor. So these are the three critical things that the Act covers. Now, an in-house counsel, therefore, based on these three observations, need to look at the following key areas, in my opinion. Again, making it very clear that this is not a very, very exhaustive list, but a suggestive list of things that an in-house counsel need to keep in mind to make sure that we are on the right side of the Contract Labor Regulation and Abolition Act and do not commit any violation. At the same time, we keep monitoring that our contractor is duly compliant with all the obligations under the Act. So here goes the list. First and foremost is be very clear that the statute does not intend to allow deployment of contract labor in jobs and tasks which are perennial in nature. The moment you start deploying contract labor on jobs which are perennial in nature, you're bound to fall foul of the Act. And that's the reason why there's a provision for says the appropriate government to issue notifications for prohibiting and abolishing, and now state governments or the appropriate governments have started using that section to issue notifications for certain areas where they allow deployment. So keep that in mind. Second thing, keep an eye out for notifications that are issued from time to time by the appropriate government to be aware of the areas where the appropriate government intends to prohibit or allow deployment of contract labor. The third thing is make sure that all the contracts that are entered with the contractors have certain representations and warranties from the contractor, which are duly backed by the indemnities. For what? Covering registration requirements, other contractors covering labor law related compliances to be done by the contractor, maintenance of registers and all other documentation, registration, etc. Uh, uh, Related obligations. The payment of wages, minimum wages, bonuses, PF, CSIC, and all those payment related obligations, everything is covered via the reps warranties, covenants, and are adequately backed by the indemnities within the contract. That's the third thing that you need to make sure. The fourth thing is that you make sure that the contract duly allows you as a principal employer to seek information, documents, evidences from the contractor at any point in time during the tenure of the contract, or maybe after some time of termination also, that he's complying with the labor law requirements. So you as principal employer should have that right to seek information and documents from the contractor within your contract. The fifth is to build a process within your organization, work along with your typically these areas are taken care of by the industrial relations team within the manufacturing organizations. So try and work with them to build the process of verifying payments made by the contractors to the laborers, and also cross checking the same with the actual sample data to make sure that it is adequately compliant. Also, build a process and scope within contract to be able to penalize the contractor if you uh, uh, in any of the cases find out that there are non-compliances. So when you do the audits and you find out that there are non-compliances, have adequate provisions in your contract by which you can penalize the contractor, so there is adequate deterrent in your act to make sure that the compliances are done by the contractor. And last but not the least, make sure that the industrial relations team are renewing the registrations on time and are also making their contractors to make registrations and renew their registrations from time to time. If you take care of these five or six or seven areas that I spoke about, uh, you can be pretty sure that you will be on the right side of the contract. While it still is, as I said, is just a suggestive list of things that you need to do, it still will take care of the majority of the areas, and therefore you can be secured from the uh, point of view of compliances under the contract labor regulation and abolition. There may be several other things that one may need to keep in mind to be fully on the right side uh, when it comes to the Contract Labor Act, but the same may need evaluation and advice and suggestions on a case to case basis also. Uh, this list that I spoke about is just to create an awareness on key issues that in house legals need to take care of, and in the process need to follow after onboarding of your contract labor. So I hope that today's discussions were useful for you. Feel free to reach out to me in case you need to discuss something in detail or want to speak on any other relevant legal issues around OEMs, and I'll be glad to engage with you and discuss those issues. If you like the content that I'm creating for this podcast, do let me know that too. You may also write to me to suggest the legal subjects that you would like to listen to, and I'll try my level best to bring those to you. And if you are among those 71% of the listeners who are listening without subscribing to the channel, this may be your uh, time to kindly subscribe to the channel so that you get the notifications from time to time. And we have enriching engagement on certain relevant legal issues that we can discuss together. We'll meet you again with a new topic next Friday. Till then, please take care and namaskar.